When I argued cases in the Supreme Court, the process of preparing for an argument was always a roller coaster for me. I would get excited, I would be all up and pumped, and then I would say, oh God, why did I agree to do this? I don't have to do this. I'm a law professor, I can profess. It's not coming together right. And then finally, after all of that Sturm und Drang, I would stand up and I would say, Mr. Chief Justice, and may it please the court. Then all the anxiety would drain. I could almost feel it draining from my feet. I would be in the flow. I didn't prepare the way most people do. I didn't do moot courts. I immersed myself in the history and the relevant materials and the record of the case. I had these I guess people called them argument boards, and I measured the entire podium, which has a little rectangle cut out at the top for the lights. It didn't honestly matter, but it mattered in a ritualistic way. As I prepared, I wanted to have the actual podium in front of me. It was like a comfort blanket or something. It was something that I knew that in extremis I could look at, but I didn't. It was the process of writing them that cemented things in my mind so that I didn't really have to look at them. They always had multicolored entries: red, blue, yellow highlighting, green. How I chose the colors, I don't remember, but they felt very purposeful to me. In particular, I almost always used blue or black for points that I thought it important to make, and red for rejoinders that I thought were the strongest arguments my opponents might make. This is an example of one of them in the case of Bowers versus Hardwick, the case I argued involving same-sex intimacy and personal privacy in 1986.
Mr. Tribe.
Mr. Chief Justice, and may it please the court.
It starts with, this case is about the limits of government power.
The power that the state of Georgia invoked to arrest Michael Hardwick in the bedroom of his own home.
It is not the power to preserve public decorum, because nothing here was done in public.
Power invoked here, and I think we must be clear about it, is the power to dictate how every adult, married or unmarried, in every bedroom in Georgia will behave in the closest and most intimate personal association with another adult.
Objection. The 14th Amendment's framers assumed that unorthodox sexual intimacies could be banned. I wrote that as a point that I knew would be made by the state of Georgia defending what it was doing in Michael Hardwick's bedroom. And I wanted then to say, well, they also assumed that women were property. They also made a number of other assumptions. Surely we're not bound by them. And I would do a kind of flow diagram, red, blue, black, yellow highlighting, of what I anticipated the exchange would be.
Professor Tribe, would you distinguish the home between the back of an automobile?
Certainly. We would say that in Onofre, for instance...
What about a hotel room overnight?
Would it be permissible, in your view, for the state to prohibit heterosexual conduct between males and females who are not married to one another and not married to anybody else?
Mr. Tribe, how do you propose that these other situations be analyzed? What is it you're saying?
Well, Mr. Tribe, why isn't it more proper for this court to let it be reflected in the majority rule where, states have repealed these statutes?
Justice Rehnquist, this court has never before held that when a personal right is protected by the Constitution, just because those persons might be able to obtain political redress, the right no longer deserves judicial protection. Indeed, in Justice Powell's dissent...
Back in the period, mostly from the mid-'80s to the '90s, when I was arguing most of my cases, the court was a very hot bench. They would interrupt one another. They would interrupt you right in the first 10 seconds of what you argued. So you had to be kind of very fluid, ducking and bobbing and weaving. And I loved that spontaneous interchange, and I loved having my security blanket to anchor myself with.